Really, we're dealing with the certainties in life, and if we put it in such trite terms,
Yeah, the two jolly ones, death and taxes.
might as well get that out of the way now.
Absolutely, yes. But it's an area that's been in the news a lot since the pandemic, obviously, and thereafter. And we've seen of late a lot in the news about tax. And so it is an area that affects more and more people as wealth goes up, property values go up, and that's where we're here to help.
Welcome to Listen Without Prejudice, your exclusive gateway to one of London's leading law firms. In each episode, we dive deep into the stories, insights, and expertise that make Bishop Sewell a trusted name in the legal community. Join us as we explore everything from the latest legal trends and case studies to practical advice on residential and commercial property, corporate and commercial law, employment, family and divorce matters, private clients, and dispute resolution. Whether you're a legal professional, a client, or simply curious about the law, Listen Without Prejudice is here to inform, inspire, and engage. Now, without further ado, let's get the conversation started.
Well, welcome to the show, and we're very lucky to have with us today Nicholas Barlow, who heads our private client team. And Nicholas, you're going to be talking to us a little bit about the work that the private client team does. So perhaps let's just begin by talking about that.
Absolutely. Private client is one of those areas of practice you have to explain quite carefully to people, but the fundamentals would be preparing wills, dealing with a situation after somebody dies, powers of attorney for somebody who's vulnerable or needs some assistance with their financial affairs, and just the full range of private wealth and succession planning that comes with a well-established firm like ours, where you have families that need assistance throughout the generations.
I think also perhaps as well, although we say, slightly tongue-in-cheek, is a satiric topic, of course it is a very, very serious topic, but it is something where people have got the ability to take some actions themselves. You can plan ahead, and you can plan ahead for those around you as well, and perhaps that might be comforting perhaps in certain circumstances.
Absolutely. Yes, I think you need to take ownership of it, as you've rightly said. We all know we're all going to pass away one day, and sadly our loved ones will as well. So if we can set things up to support the rest of the family, those who are left behind, to make sure that everything is well documented, they're not going on some treasure hunt trying to find assets, providing some guidance as to your wishes and your thoughts, and really your priorities for your succession, it's really important.
Indeed. So perhaps that's a good place to start. So perhaps let's just think about the alternative. So obviously we're helping people who've taken the decision to come and do something about this, but what would happen if you don't make a will?
Well, the legal term is you'd be intestate, and there's a standard set of rules that come into play there that date back many years, the non-contentious probate rules. And it can lead to great disappointment because it prescribes certain beneficiaries who really are next of kin, depending on who survives. And that may include a child who's estranged or a load of cousins you haven't seen for a very long time, and would certainly exclude what people refer to as a common law wife or husband. Long-term partnership, if it's not a civil partnership and no marriage, they get nothing.
Right, so it's quite dire if the appropriate steps haven't been taken. So really something to think about. I mean, let's just come on to that. And then families, children perhaps as well. So what would happen in the case of children?
Well, under these rules of intestacy, children become entitled at 18 years old. And as the father of 5 children myself, I certainly don't think 18 is quite the right age to inherit any significant sums of money. So where wills are being drafted, we'd tend to postpone that to 21 or 25 years old, when people are a bit more settled in life, a bit more mature, and aren't necessarily listening to the views of others when making key financial decisions.
Yeah, I think there's also perhaps some questions around guardianship as well, and what one might want to do there, speaking as someone who's got 4 children myself. So I mean, that can be a difficult conversation.
Absolutely, and that tends to be the thing that holds up the preparation of a will. It is a very important decision, who would take on parental responsibility. Bear in mind, it's only after both parents have passed away. So statistically quite rare, you're absolutely right. But in that unhappy scenario, if there hasn't been a decision exercised, the court has to decide, and at a very difficult time. So it really is something that, if you do nothing else in your will, work out who's going to look after the children.
I think perhaps it's one of those things, like all those life events that sort of move on into the next generation. Having children is one of those. This is perhaps, although it's a very happy time and a time of joy, a time to start thinking about some of these issues quite seriously because of the responsibilities that come with that step.
Yes, some grown-up conversations are needed at that time. Yes,
absolutely. And perhaps also promoting conversations with the next generation as well, because it's all part of an intergenerational plan, perhaps. People also ask a lot about the practical side of things, the things that people do care about that may not necessarily feature in a will directly. So personal assets, let's say jewellery, artwork, or something which is extremely personal to somebody. How would you deal with those?
We'd always have a clause in the will that says, if I've left any written wishes, can you please follow them? And to my mind, written wishes, that would include a post-it note behind the painting that everybody loves, or a little notebook. That's what my grandmother did. She diligently jotted down who was going to get what. And that can be something for the family to share the enjoyment of that. But I've seen all sorts of methodologies. One of my favourites involved 2 bottles of champagne to start with that needed to be drunk by everyone in the room. And then they took cards, and the highest card had first choice of the items in the house. And so it led to quite a jolly afternoon, apparently.
Well, everyone's different, aren't they? And you've got to think about those things. But perhaps it comes back to the point we were making a minute ago about being in control in a situation where perhaps you are no longer there, or you're looking into the future, trying to make provision for others.
And that can be hugely divisive as well, the personal chattels, to have such sentimental and emotional value. I've seen families not particularly fussed about the money side of things, but who gets the Welsh dresser in one case. Brother and sister fought like cat and dog over it. And I think following the loss of a loved one, it can bring a lot of suppressed emotions up to the surface. And so again, leaving some clear wishes, clear notes, that's going to diffuse those tensions which may exist in the family.
I think maybe that's another thing to go back to, another really important point. Actually, what does someone want done in terms of funeral arrangements? Because, of course, that's not something necessarily appears in the will, but I mean, what's the guidance there?
You might put a line in the will saying, I wish to be cremated, I wish to be buried. But beyond that, the detail of it would be in a separate note. Very personal and, to be honest, very helpful indeed. If the family can get a steer, whether it's favourite hymns or readings or poetry, or the location, whether it be a woodland burial or just, get rid of me at the local crematorium, all that will help. I know it's part of the sort of grieving process going through it, but I think everyone really appreciates a bit of a steer.
Yeah, I suppose the guidance must be to put that in somewhere where people can find it, or that those wishes are known, because it would be no doubt not very good to then come to the will, which you might come to later on, and then suddenly find, they wanted something different than that which we gave them. That could also cause difficulty.
Well, certainly in our case, because we are acting as trusted family advisors, and we keep packets of documents, have the will packet, and typically I'll get the message that somebody has died, and the first question is, do you know what the wishes are for the funeral? So it is important to keep a record, and no one particularly cares about where the money's going to go. It's what do we do next?
That's the emotional moment, isn't it? And that's the thing that needs to be dealt with. Coming back to assets again, I mean, there's some pretty big assets in people's lives these days. The house is one, pensions is another. How do those tend to get dealt with?
Well, with property, you would look to see if there's any co-owners. So say if husband and wife or civil partners co-own a property, it might just pass automatically to the survivor. That could be quickly checked by looking at the land registry, which we can do for a small fee, and then update the ownership with the death certificate once it's been produced. So that could be quick and easy. But it may be the case that more sophisticated arrangements are in the will. Perhaps if there are children from a previous marriage, there might be a trust structure that's in place. So again, having the knowledge and understanding of what could be set up by the will and what that means to the family is important.
It's important to consider that if those are your assets, and that applies to you clearly about how those things are going to pass. And what about pensions? Because pensions, of course, are something else that people talk about.
Yes, well, it's certainly since pension freedoms were introduced a number of years ago, a lot of wealth has been put into a pension plan by those who can manage to do so, perhaps after, say, selling a business. And usually there would be a nomination in place, so that would say who is entitled to benefit. Whether that's going to be the surviving spouse to provide them with an income stream so they can continue to live in the manner to which they're accustomed, or perhaps to have lump sums passing down to the next generation, which can be a useful way of providing for them, potentially without tax applying, more likely looking like tax will apply following some changes.
Absolutely. Okay, so something that can perhaps sit outside of the will, but something that can be dealt with as part of planning for the future.
That's certainly what we aim to do at Bishop Sewell. The succession planning is not just the writing of a will. It's looking at what happens to the pension, what happens to perhaps to a death and service benefit if you have that from your employer, life policies, what arrangements are made to clear any mortgages if they're still outstanding. So it's the broader picture, not just the devolution of your own assets.
Not the nuts and bolts of what you might call, if there ever is such a thing as simple will. Coming back to wills then, so this is something also that everyone has to think about if you're going to write a will. I mean, the idea of an executor, the person that carries out the instructions under the will, I mean, what exactly is an executor?
They're the people who step into the shoes of the deceased. So it's their job to inform all asset holders, get in touch with anyone to whom there's a liability owed, deal with the funeral, secure premises and clear the property. There's no end of jobs. So whether that's going to be best entrusted to the next of kin or perhaps to an independent professional depends on the circumstances. Certainly we find it's very helpful for us to be involved in the executorship because, well, for starters, we've got lots of experience. Family members may never have had this sad occasion previously. We've got a full team that are doing this from 9 to 5 every day rather than family fitting it in at evenings and weekends. They'd rather be getting on with their lives, I suspect. But yes, the executorship role is lifelong. It's mandated by the will. And once you start acting as executor, you've got to finish the job. So again, getting advice at an early stage is really important.
Certainly not. Yes, it's quite a weighty responsibility.
Absolutely.
So coming back to who to pick, then I think then people often think, well, I'll pick one person from one side of the family, one from another. And as you've just said, perhaps also picking a professional, indeed picking a professional, if that's the right way forward, can be helpful.
And it's worth reviewing your will, because once you do prepare one, perhaps look at it every 5 years or so, because your great pal from university may not be the right person to deal with the estate administration after, a few decades have gone by.
The person you thought of 15, 20 years ago might not now be equipped to deal with some of the things that you now have in your estate. So, obviously we're talking about the inevitable circumstance, but also IHT taxes. Should I be scared? What can you say about that?
There's an allowance of up to £1 million. So a married couple, under present rules, will have at least £1 million worth of allowances, which will then extend to the point in time when their children or other relatives inherit. Transfers between husband and wife and civil partners are entirely tax-free. So inheritance tax, not necessarily something to be feared, but to be mindful of and to plan ahead. That's the most important thing. Most people have heard of the 7-year rule when it comes to making gifts. I saw a client recently who started his gifting in 1984, and he sort of rolled his eyes when we created a further trust, and he said, oh, not another 7 years.
Planning ahead, I think, is the way there. So once again, can't necessarily completely be escaped, but can be mitigated if the appropriate steps are taken. Just to say, coming back to this discussion about family and the wider context, the generations. Let's say I'm in the lucky position of having well-off parents. What should I say to them?
Depends on your relationship with your parents. But they too will be mindful of inheritance tax. It's very much a national conversation at the minute. It's hard where the value is tied up in the family home, because no one wants to feel as though they're being encouraged to move out, but there can be ways of extracting value from the property to fund lifetime gifting. We've both read a lot about the bank of mum and dad who are helping out at the minute for children in their 20s and 30s trying to get on the housing ladder. It's the economics of it makes it very, very difficult for people to do that independently. So we're seeing actually those discussions taking place earlier than they may have done a few years ago. The idea of passing on wealth when you can do, not least of all to see the benefit of that transfer of wealth. Children moving to a larger house, saying thank you. You can go around and visit.
Lifetime, yes.
Exactly, yes. So that's usually a topic that can be managed, but our older clients are always worried about long-term care costs. So there's no crystal ball to say, I need to keep this many £1,000 aside to look after myself to the end of my days. And then, the tipping point at which you can afford to make gifts. It's very hard. But small and often is quite tax efficient, so it's worth starting early if you can afford to do so.
But I think some of these conversations, they springboard a wider conversation. So let's say somebody younger comes and makes their will, then they can sometimes say, actually, you know what, I think it might be time for everyone to think about this as a family. What do we all want here? Or if the parents are older and they're going to inherit, and perhaps that puts them in a position where they're going to have quite sizable estates, there can be things that can be done to plan around that. And it's important to start that conversation.
Yes, you could call it a family charter, if you will, sort of the idea that everyone is going to think about their succession. We said inevitably there will be a transfer of wealth. There's a statistic at the minute, the anticipated transfer of wealth from the baby boomer generation downwards, a huge amount of money that's built up over that last 70 odd years or so. So I think sitting down as a family, possibly not on Christmas Day, but when the moment is right, and to talk about these things and plan ahead, perhaps thinking about executors or, say, funeral wishes as a lead-in. That tends to be the sort of start of the conversation. Certainly my parents are going to funerals every other week, it seems, at the minute. So it prompts these discussions and thoughts.
Yeah, when someone else is passing on, then perhaps that's a time at which that would be a natural time to bring that conversation up. We were talking about making a will. I've heard people say you don't need to go to a solicitor to get a will drafted. You could get it done online. Is that right?
It is a possibility. As with all things, there's a DIY option, but it's if anyone's seen my DIY skills, it's probably best to get a professional involved. For the very simplest of circumstances, it can work, although I looked after a trust that had been accidentally set up by a homemade will that lasted for 21 years because the lady who prepared it got a kit from, I think, W.H. Smith's and filled it in, and the terms of it were that until her eldest grandchild was 25 years old, the trust created by the will just kept on going, which led to a certain amount of disappointment by the other family members who wanted their money.
I was going to say they probably couldn't get entitled to their assets and they weren't able to take them because they weren't available.
There are will writers as an alternative to solicitors, but they're not qualified legal professionals in the same way that we are. As you well know, the journey to become a solicitor takes many years and lots of training and a very high standard of care to our clients and professionalism.
So I think there are options out there. It's about having the right thing for you, your budget, what you're looking to achieve. One thing that people do often ask about is, what's the extent of my will? What about property that I own overseas, let's say?
Very good question. We've got a lot of clients who have property in Europe, Switzerland, further afield, Commonwealth countries, and that needs to be flagged when you're preparing your will, because the English system of preparing a will and naming an executor, which we've discussed, may not be relevant in another country. Say in France, a lot of clients have property there. The idea of an executor is unknown. Assets go straight to a beneficiary. And so you need to accommodate for the English system of law, which might favour your surviving spouse being the only beneficiary against the forced heirship rules of other countries, certainly continental Europe, where children have a fixed share. And under the inheritance tax regime, that can trigger an unwelcome tax bill on the first death. So part of the preparation of the will is looking at whether there's foreign property, looking at the local rules, deciding whether that's compatible with what the client wants to accomplish. And then we can partner with local lawyers to see if it's appropriate to prepare a will, say, France, Spain, Portugal, wherever it might be, next to a nice golf course or a ski chalet, wherever they own their property, looking at the imposition of tax and potentially putting in particular clauses in the will that allow English law to apply in overseas jurisdictions to make sure that your wishes are met. Again, it's not uncommon, but it requires a more experienced practitioner to understand that, and many of our clients are in that situation.
I've heard you can vary a will even after somebody's died. Is that right?
It sounds stranger than fiction, but it is true. And a deed of variation or a deed of family arrangement are phrases that are sometimes used. A variation is where you have a written will. Famously, the will of Princess Diana was varied to, I think, extend the period of time in which her sons would have to wait for their inheritances. Probably not a bad idea. A deed of family arrangement is where there's an intestacy, so there hasn't been a will left. And it might be the case that perhaps an older member of the family who doesn't really need the money is the next one entitled, and they may come to an arrangement to move part or all of that inheritance down a generation. Some basic rules. It's a document, has to be prepared within 2 years of death, and it can simply redirect the assets. We've had some that have been done for asset protection reasons, perhaps because of vulnerability, or they've been done to just have greater tax efficiency, or to make provision for charities, or for perhaps carers who've been involved in the latter stages of someone's life, where the family want to make a gift but want it to seem as though it came from the deceased rather than from their own pockets. It just seems more appropriate that way. Simple and straightforward documents, and again, easily prepared.
So also we talked a little bit about trust. You mentioned the trust, the accidental trust, but what about a will trust? What's that all about?
Well, a trust is an arrangement whereby the executor of the will becomes a trustee once you know what's in the estate. So once you've paid off all the debts, liabilities, any taxes, you'll have a pot of cash or assets remaining. And it may not be appropriate to simply hand those over to the next person entitled. I mentioned earlier the situation where you have children from a previous relationship, and there may be a wish to look after perhaps one's second wife or husband, keep a roof over their heads, make sure they've got enough income, make sure the care is paid for if that's necessary, but preserving assets for the children of the previous relationship. So that would be a classic trust situation, known as a life interest trust. You can also have discretionary trusts, where you'd have a whole list of beneficiaries that might include family members, might include charities, friends, whomever it may be. And the trustees would follow a separate note of wishes, which is a private document, address just the trustees and setting out how one's inheritance should pass on to that list of potential beneficiaries. None of them has a right to an inheritance, so it's at the discretion of the trustees, which can be helpful if there's been a number of years that have passed since the will was prepared and the time of death, and circumstances may have changed.
Right, so it gives greater flexibility, perhaps, if things are going to perhaps be a little bit complicated.
There may, for instance, have been no grandchildren when the will was drafted, but 7 of them at the time of death, and using a trust structure, you can make provision for them, perhaps to preserve assets, maybe to the age of 25. Particularly helpful using trusts where you've got family businesses or other sort of more complex assets, large property interests, making sure that someone is responsible to look after that property, which would be the trustee, and maybe a number of beneficiaries, particularly suitable for a family holiday home, for instance.
So do you have any other basic tips for anyone thinking about making a will?
A will can do just about everything. So, starting with the basics, who are you going to entrust to look after the administration of your estate and your assets? Very important role, and I'd suggest a mixture of family and professional support would usually be advisable. Guardians for the children, what's going to happen to your animals? Everyone's very concerned about their pets. Certainly clients who own horses, they need to think about who's going to look after them. They're expensive. Specific gifts, certainly for family businesses or other business interests, and how they're going to pass down. And then looking at cash gifts, known as legacies or bequests, we can give away certain specific assets, and then just the remainder, known as the residuary estate, how that's going to be divided, whether it's going immediately or perhaps in trust. So that whole conversation, dare I say, it needs to sit down, a face-to-face talk, and perhaps filling out an online form and doing a cheap and cheerful will may not cover everything you need.
Quite a lot to think about there. So, Nicholas, thank you very much for talking to us. I'm sure we'll come back and talk to you again. And thank you for sharing your time with us this morning.
That's all for today's episode of Listen Without Prejudice. Whether you're navigating a property transaction, a corporate, commercial, or family matter, we're here to guide you every step of the way. If you enjoyed the episode, don't forget to subscribe to stay up to date on future episodes, where we'll continue to explore the latest trends and challenges across our core practice areas. Do you have a question or topics you'd like us to cover? Or do you want to reach one of our experts? Feel free to get in touch via LinkedIn or through our website, bishopandsewell.co.uk. Thanks again for tuning in. Be sure to join us in our next episode, where the conversation continues. Until then, take care.